Any technology company has what I call a widget. And that widget, broadly defined, could be a kind of instrument, it could be a flow cytometer, it could be a piece of software, a mobile application, it could be a drug or anything that distinguishes that company from its competition. And this widget is something that brings value to the company, brings in the revenues. But what most people don't understand, when you're out in the marketplace and your widget is not protected legally, then somebody can come and take it, steal it, copy it, reproduce it in competition with yourselves. So we need to talk about what that legal protection means. Is it a copyright? Is it a trademark? Is it a patent? Or is it simply a trade secret? Another reason to protect your widget or technical innovation is because investors and potential buyers of your company understand that if your technology is protected legally, then you can hold on to the value of your company more than if it was something that somebody can just walk away with tomorrow. So it's important to have that protection to increase and maintain the value of your company once it's time for an exit. Finally, there's also the third aspect of enforcing your IP rights. And I just want to tell you that if you want to get into the IP business, it's a very serious business. And by serious, I mean expensive. When it's time to enforce your rights because somebody is in fact infringing you, and they're not listening to me, the lawyers, or yourselves when you're trying to negotiate them, it's time to hit them over the head with a hammer. That means suing them and getting an injunction and getting the judge to grant you damages, including the expenses of suing them. So all these things, three things that I talked about, establishing, exploiting, and enforcing your IP rights are all connected. And you need to think about all three things when you're starting a company, getting the revenues up, and when it's time to sell.